Hello, everyone. We're just going to give a little time to make sure everybody's logged on. So we're going to for just a minute or two. All right. Well, hopefully everybody is present and logged on and you don't have any trouble with that. So hello and welcome to our quarterly sample policy update series. We're so happy that you are joining us for our discussion today that focuses on the September policy packet. Before we get started with the content of the policies, let's go over the layout of the webinar. Next slide, please. We will start with housekeeping and presenter introductions. Then we will move on to the policy updates. And then there will be time at the end for Q&As. Next slide, please. So just for a few housekeeping tips, please use the Q&A feature to submit your questions. This is located on the ribbon below the speaker. The chat feature has been turned off, so you can see from our picture here, the image, where you should go for the Q&A. Your questions will be answered either in the Q&A feature in writing or live by our presenters. And all attendees will receive a link to the video of this webinar as well as the slide deck. Next slide, please. And now for an introduction of our knowledgeable and thoughtful panelists. Josh Daniels, who is Chief Policy and Governance Technology Services. Mary Briggs, who is the Senior Director of Research and Education Policy Development. Meghan Russell, who's a Senior Policy Manual Writer. Dustin Bindreiff, who's also a Senior Policy Manual Writer. And Maryela Martinez, who's a Senior Legal Services Attorney. And then myself, Barbara Laifman, I'm the Director of Policy Manual Development. Maryela will start off by giving a brief overview of CSBA District and County Office of Education Legal Services and what these services offer to districts that subscribe.
Thank you, Barbara, and thank you all for having me here today representing the legal services team. As Barbara said, my name is Maryela Martinez, and I'm a senior legal services attorney. I'm here because there have been many changes in the law that affect board policies and administrative regulations since the last update. And I'd like to walk you through some of those before turning it over to my colleagues in policy to discuss how the policies have been revised to reflect these legal changes. But before I do that, I do want to share a little bit about legal services. The program has been in existence for a couple of years now. It was launched at AEC in 2021, and it was designed to provide direct and confidential legal advice to CSBA member districts and COEs in a very cost-effective manner. And we handle a wide range of matters, including, for instance, independent investigations, custom policy drafting, special education, board governance, consulting on education-related matters, and really every aspect of education law we are able to handle. Our subscribers receive a host of benefits and discounts, but I do want to mention one in particular today because it's very timely, and that is discounts on trainings that are put on by legal services. So we have a Brown Act training in Madeira coming up here in a couple of weeks on October 13th. And that training is specifically geared towards executive assistants and board presidents, although everyone is welcome. I also wanted to mention that there's one last thing here before moving on to the reason we're all here today, and that is a new partnership between legal services and policy. So if you're a Policy Plus subscriber and you join us at Legal Services, you will be entitled to 2 hours of policy-related work by legal services attorneys. So for instance, advice on implementation of board policies and administrative regulations, or customizing them for your district or COE. And that's, of course, on top of the 3 hours of legal advice, free of charge for all new legal services subscribers. So you're looking at a total of 5 hours of attorney time free of charge. So if you're interested in learning more about our program, you can contact us at legalservices@csba.org.
Thanks so much, Maryela. Contact information for CSBA District and County Office of Education Legal Services will be provided at the end of the presentation, which will be useful if you are interested in subscribing or learning more about CSBA's legal services. And now what we're all here for are highlights from the September policy packet. So I think actually next 2 slides, please. What you will see here is a complete list of the policies that were updated with the September packet. We will be discussing all of them today, except for Board Policy and Administrative Regulation 1330, use of school facilities, and Board Policy 3460, financial reports and accountability. If you have any questions on these 2 or any of the materials discussed today, they can be addressed at the Q&A after the presentation. We will also provide contact information for further inquiries. I'd like to now introduce Dustin to discuss policy developments in artificial intelligence.
Thank you, Barbara. Drafting sample policies related to the explosion of machine learning or generative AI and academic honesty was a neat experience. Because the technology is evolving so quickly, there was a lack of legal and professional guidance. So the first question we had to tackle is, what is different about generative AI? Tools such as autofill, spell check, Siri, and Alexa are established forms of AI as well. So we had to really try to figure out what is different about ChatGPT and other generative AI technologies. So we settled on utilizing the most encompassing term possible, technology, and working to provide acceptable use guidance around that. This began with restating the broad goal of schools, which you see here, and then defining prohibited uses of technology as anything that undermines this goal. Next slide, please. Next, we had some lengthy discussions trying to detail the scenarios when it would be acceptable to use generative AI and when it would not be. This too was filled with gray area. So we spent a great deal of time discussing the optimal descriptions of prohibited uses of AI, focusing broadly on using it to complete assignments or generate answers to problems as prohibited. This list can be modified to fit your district's practices. The permitted uses that were included are more consistent with traditional forms of AI and instructional practices. With the wide range of variability from teacher to teacher, we had to do a great deal of discussion about being overly prescriptive in our policies, not wanting to limit what individual teachers are allowed to do in their classrooms. And that is another aspect boards will want to consider when they revise and adopt and implement these policies. Next slide, please. Finally, we wanted to provide some guidance. Up one, please. Oh, never mind. You're correct. Thank you, Josh. Finally, we wanted to provide some guidance related to what teachers will do when they have concerns about the authenticity of a student's work. The practices we found most common and effective were asking students to demonstrate how technology was used. And then when teachers use a AI detection program, providing students an explanation of how that program was used to detect plagiarism. Finally, we wanted to encourage professional development and guidance for teachers in the implementation of these sample policies. Much of the challenge and opportunity of AI falls on individual teachers, and there is a great deal of variety in the individual comfort levels with their use. So from a policy perspective, we spent a great deal of time navigating the balance of providing boundaries and respecting teacher autonomy. As the use of generative AI continues to grow, teachers will need ongoing support and guidance to implement your district's goals and boundaries on technology use. Next slide, please. We also added abbreviated versions of the academic honesty language to BP 6154 and BP 6162.5. These policies provide some additional clarification on how and when technology may be used for homework and assessments. Additionally, we referenced academic honesty in these policies where the heart of the guidance is provided.
Thanks so much, Dustin. Next slide, please. And now we will hear from Mary in regard to CSBA's Artificial Intelligence Task Force and other work CSBA is doing in the area of artificial intelligence.
Thank you so much, Barbara. As you've heard today, I am from the CSBA Research and Education Policy Development Department, and I'm really grateful for the opportunity to participate in this conversation. The policy team was kind enough to invite us to participate today because in addition to the policies that are in this packet that address AI, CSBA is working on this issue in a range of ways. And today I'm here to talk about two of those. The first of these is the AI task force. CSBA in May had a board of directors meeting where they approved launching a new task force on artificial intelligence. It's really aimed at equipping boards of education with the knowledge and tools that they will need to address the complexities of responding to how artificial intelligence is impacting education and the work of public schools. We want to make sure that our members are ahead of the curve so that you can maximize the benefits of artificial intelligence while simultaneously safeguarding the welfare of your students and supporting their educational development. So with that task force, a couple of details. In June, CSBA sent out an email announcing the development of this task force and requested nominations for interested parties. It is a presidentially appointed task force, and the protocol was developed over the summer. The nominees were reviewed, and we had more nominees than we could fit on the task force, but we're very excited about the work moving forward. The membership will be ratified along with the protocol at this week's September Board of Directors meeting. Just a couple of details around the composition of the task force. It will include a range somewhere between 23 to 27 board members, superintendents, administrators, and pre-K to 12 IT experts. We will also be bringing in additional experts that serve as task force advisors in relation to work of subcommittees that are developed throughout this task force. So we're very pleased to see this work going forward. We will anticipate seeing a few things that we anticipate will be developed. Will include things like how boards can support positively integrating AI into educational settings, including career technical education and other content areas. There will be discussions of key ethical, legal, and privacy implications of AI use and help identifying appropriate policies. In addition to that, we have already released a new brief. Karina Arroyo from CSBA has drafted a brief that is addressing policy considerations specifically for governance teams. It's available on our CSBA website, and we've included a link here on the slide as well. What you'll find within that brief includes an overview, but more importantly, I think, some of the key policy considerations, some sample questions that board members might ask of district staff when discussing issues around artificial intelligence, as well as additional resources. So this is kind of our first foray into providing some direct resources to our members, but as the task force continues forward, they will be releasing additional guidance and support for our members. And with that, I'm going to hand that over to Barbara. Thank you so much.
Thank you, Mary, and thanks so much for joining us today. Next slide, please. And with this slide, we will welcome Maryela and Meghan, who will be presenting on legal and policy implications related to facilities and food service operations.
Thank you, Barbara. We're going to switch gears completely now and discuss some changes related to bidding. Just as a reminder, Public Contract Code Section 20111A requires school district governing boards to competitively bid and award any contracts involving an expenditure over a certain amount, and these must be awarded to the lowest responsible bidder. Per the Public Contract Code, this amount is adjusted for inflation, and the annual adjustment for 2023 was announced by the California Department of Education in December of last year. So the CDE increased the bid limit for 2023 to $109,300. And it's important to note that this new bid limit only applies to three categories of contracts, not other contracts, but just these three. And these are, first, the purchase of equipment, materials, or supplies. The second is services that are not construction services, and that's important, the fact that it's not construction services. And third, repairs, including maintenance, that are not public projects. So obviously, in light of this third component, we need to know what public projects are, and the term is defined in Public Contract Code Section 22002C. And these projects, public projects, have lower bid thresholds of $15,000, and that is not adjusted for inflation. And this, let me just, as a little side note, that the $15,000 threshold applies unless your district or county office of education has opted into the California Uniform Public Construction Cost Accounting Act, which is also known as CUPCA. But a discussion of that is well beyond the scope of today's discussion. So I'm not going to elaborate any more on that, but just keep in mind that there are potentially some exceptions to that $15,000 limit if your district or COE has opted into CUPCA. So still on the topic of bids, last year, the State Allocation Board affirmed one of its previous decisions that contracts to acquire building components for installation on permanent foundations, and this is critical, to acquire building components for installation on permanent foundations. These must be competitively bid. And the board also clarified that piggybacking for this type of contract cannot be used. For those of you who are not familiar, Public Contract Code Section 20118 permits school districts, thank you for advancing that, school districts to purchase personal property from a vendor without competitive bidding if they piggyback, here's that term, on a contract that the vendor has with another public agency, so long as the same terms are used in the new contract. So at any rate, this clarification from the State Allocation Board is very important to keep in mind. Because these piggyback contracts to acquire building components for the installation of permanent foundations, will be ineligible for state funding from the board if submitted after August 21st of 2022. So that's obviously something that we need to keep in mind. So one more on the topic of bids, and we've got, if we could advance the slides, we've got AB 185, which is a big bill. And it does a lot of things, but for my purposes right now, it authorizes an alternative design build construction method for K-12 school districts. Again, a lot of these terms may not be familiar to most, so let me tell you a little bit just as background of what design build is. And it is a type of delivery method. And generally, typical competitive bidding involves two contracts. So one for the architect and one for the contractor. But when you are dealing with design build, This allows public entities to enter into just one agreement with one design build entity, which would complete the design of the project on the one hand, and then also construct it. So both the architect and the contractor would be employed by the same design build entity. So we have a table here in our slide deck that compares traditional design build and alternative design build for you. And I do want to highlight what I find to be the most important difference. And that is on the second row there. You'll see that the selection of the design build entity is based on low bid or best value for both methods, for both traditional and alternative design build. However, for traditional design build, if the selection is based on best value, just best value, not low bid, the request for proposals has to include factors to be evaluated, and that includes the price, again, unless a stipulated sum is used, but just generally the price, the experience of the entity, as well as the life cycle costs. In contrast, though, for alternative design build, if the selection is based on best value instead of the specific price, design cost, general conditions, overhead, and profit as a component of the project price must be proposed instead. So after the contract is awarded, what this means is that the district will evaluate the costs based on the final design to set the price of construction then. At this point, the contract may be subject to further negotiation or amendment or even termination if the terms cannot be agreed upon. So one more thing on design build, and that is the traditional design build sunsets on January 1st of 2025, and alternative design build on January 1st, 2029. So that's it for me for the time being.
Good morning. My name is Megan. I'll be talking a little bit about the policies related to bids, design, build, and services. So Maryela talked about kind of the legal updates, and I will be discussing about how we implemented those in policy. So for AR 3311, which is bids, we clarified that for lease, leaseback, design, build, and alternative design, build projects, the notice needs to specify that the project is subject to skilled and trained workforce requirements, and that's optional for all other types of projects. And then for AR 3311 bids, AR 3311.3 design build contracts, and AR 7140 architectural and engineering services, to all three of those policies, we added language about alternative design build as a construction delivery method that Maryela just summarized. And again, that's for projects over $5 million, and it's available until January 1st, 2029. So I will hand it back over to Maryela now.
Thank you, Megan. We are going to be moving on to a totally different topic now, and that is the Buy American Food Act. And that was added to the Food and Agricultural Code by SB 490, which was signed into law in 2022. So SB 490 applies to local educational agencies that operate the school nutrition programs and receive more than $1 million in annual federal meal reimbursement. And that includes the National School Lunch Program, the School Breakfast Program, as well as the After School Snack Program. So these LEAs have to do two things. The first is to specify in solicitations for bids and contracts for agricultural food products that only purchase of agricultural food products grown, packed, or processed domestically is authorized, unless a specific exception applies. And there are three exceptions that I want to go over here with you. The first is if the bid of or the price of a non-domestic product is more than 25% lower than the bid or price of a domestic product. The second exception is if the quality of the domestic product is inferior to the quality of the non-domestic product. And the third exception is if not produced domestically, if the product is not produced domestically in sufficient and reasonably available quantities of a satisfactory quality. So the second thing that an LEA has to do per SB 490 is to retain documentation for 3 years from the date of purchase. Finally, for SB 490, it's in effect from January 1st, 2024 through January 1st, 2029. So if we could advance the slide, and we will be discussing then AB 778, which is also a 2022 bill, and it addresses the purchase of California grown agricultural food products. So what AB 778 does is remove the requirement the school districts accept bids or prices of California grown agriculture products if the price does not exceed 5% of the lowest bid for agriculture products produced outside of California. AB 778 also requires LEAs to accept the bid or price for agricultural food product when it is grown in California before accepting bid or price for domestic agricultural food products that are grown outside of California. And this happens when two other things happen, and that is number one, when the bid or the price of a California grown product does not exceed the lowest bid or the price for domestic products produced outside of California, and number two, when the quality of California grown products is comparable to the domestic product produced outside of California. So with that, I'll turn it over to Megan again for more discussion on this topic.
Thanks, Maryela. So Maryela just discussed SB 490 and AB 778, and those were integrated into Board Policy 3551. And so I will now be talking about Board Policy 3551, but just know that we also updated those policies to include those Buy American statutes that Maryela just discussed. So there has been a USDA memorandum since 2016 saying that districts participating in the National School Lunch and or Breakfast Program are mandated to adopt policy addressing meal charges. So we have that in our sample policies, the BPAR 3551, but recently, actually just this year, CDE came out with a new bulletin that says that districts that operate a non-pricing program, which is California Universal School Meals, are not required to establish meal charge policies if no students are charged for meals at the schools. However, there's a potential conflict between this state guidance and federal guidance. And so CSBA is recommending that districts adopt the meal charge policy. And so that's not something that you necessarily have to adopt. Your district should already have those in place, and that's within BP 3551. But you'll notice that there'll be a change to the note for those policies and ARs. The next slide, please. So specifically related to AR 3551, we've added some language in there to address an existing law, SB 1383, which was passed in 2016, and it becomes effective January 1st, 2024 for a certain component of that law. And that is for school districts with an on-site food facility, such as a school cafeteria, will be required to donate edible food that would otherwise be thrown away to a food recovery organization unless the district demonstrates the existence of extraordinary circumstances beyond its control that makes such compliance impracticable. So we've added new language to the AR, and the new language that we added. So when you take a look at your redlined examples, you'll notice that the new language is that the superintendent or designee shall arrange to recover the maximum amount of edible food that would otherwise be disposed for donation to a local food recovery organization. And in addition to that, we've also added language about the requirement to retain records related to the food recovery and donations. And so there's some specific requirements in there, and those are reflected in the changes in the AR. And then on the bottom of this slide, you'll notice that there are some additional resources if you're interested in learning more about the new requirements. Cal Recycle is the agency that is responsible for implementing these regulations, and they have a web page that's called Resources for Local Education Agencies, K-12 Public Schools and School Districts. It's very helpful, and there's a link there. They have resources like a model edible food recovery agreement, and you can also recommend looking at your integrated waste management policy. While we didn't update that with this packet, it has been previously updated because the SB 1383 law, in addition to having requirements about edible food recovery that are going into effect in 2024, there was an earlier component that had to deal with recycling and diverting waste. And that's addressed in the integrated waste management policy. And if you're interested in learning more about this topic, we'll have an article in the October CSN magazine, and it'll be talking about share tables and food recovery organizations. And I will be turning it back over now to Maryela.
I think now, so thank you, Maryela and Meghan. We have covered this topic, and now we are going to switch. Maryela's going to stay on, and Dustin's going to join to discuss employment-related issues. Both, again, we'll cover both the legal and the policy implications. So, Maryela, I think you begin.
I do. Thank you, Barbara. Let's talk about wage overpayment first, and let's turn to Education Code section 44042.5, which was added by AB 185. This is yet another thing that AB 185 did. If you recall, I mentioned that earlier. This section was then amended by SB 141 in 2023. So this section requires that districts follow a specific process to recoup wage overpayment. And essentially, this consists of notifying the employee and providing the employee an opportunity to respond, and then determining one of the available recoupment options that are set forth in that code section. The districts may initiate legal action to recover the overpayments. And then finally, with respect to this topic, if the provisions of this code section conflict with a collective bargaining agreement or memorandum of understanding that is in effect on July 31st of 2022, then the CBA or the MOU controls, and that is until it expires or is renewed. So that is it for me with wage overpayment, and I'll turn it over to Dustin.
Thank you, Maryela. These bills were incorporated into BPs 4151, 4251, and 4351 related to employee compensation. The policy explains that if the district determines an employee has been overpaid, the district shall notify the employee in writing of the overpayment, provide the employment an opportunity to respond, and inform the employee of the employee's rights to dispute the existence or amount of the claimed overpayment. If the employee agrees that there was an overpayment in the claim amount, reimbursement shall be made to the district through one of the methods described in Education Code 44042.5. The repayment options are cash payments or installments, a payroll deduction, or an adjustment of leave credits or time off. If a mutual agreement on a method of reimbursement is not reached within 30 days of the employee verifying the overpayment amount, the district shall recoup the overpayment through payroll deductions. If the employee does not respond or disputes the existence or amount of the district's claimed overpayment, the district shall, with board approval, initiate legal action to recover the overpayment. This policy continues to explain steps to take if the employee leaves the district or if there is an outstanding overpayment balance, and steps for initiating legal actions to recoup the overpayment. Just a suggestion, when initiating recoupment of wage overpayments, it can be worthwhile to consult with legal counsel. Next slide, please.
We are back to me and a brief discussion again of another component of AB 185. And in this instance, we want to highlight the fact that it authorizes classified employees to be represented by an attorney or non-attorney representative of the employee organization designated as the exclusive representative of employees in the employee's classification. Finally, for me, a brief discussion of SB 913, which was signed into law in 2022, and SB 913 provides that for districts with an ADA of less than 250,000, the definition of length of service for the purpose of order of layoff and the determination of seniority is the employee's hours in paid status. That's it for me.
So these bills were incorporated into AR 4217.3 layoff and rehire. And quite simply, the regulation explains that if a hearing is requested by a permanent classified employee, that person, it may be represented by an attorney or by a non-attorney representative of the employee organization that is designated as the exclusive representative for a classified employee.
Hey, thank you so much, Maryela and Dustin. Next slide, please. And I'd like to now introduce Josh, who will be discussing policy and board bylaws that directly affect board members. So, Josh, if you could take it away.
All right, good morning, everyone. Thank you for joining. So we're going to discuss a few different board policies that have been updated. The first one is 1160, the political processes. This one has to do with any time a board member, current or former, which I thought was an interesting addition, signs on to a ballot measure, ballot argument, either in support or against, that there is this provision now under this new law, AB 1416, that requires you to be listed as a supporter or an opponent in the label or description of that measure. If I'm a board member and I oppose a local measure, for example, my name would then presumably be listed in the description of the measure. Now, it is up to the county board of supervisors whether to sort of turn this on or turn this off. And if they turn it on, it applies to all local measures, and turn it off, it applies to none. So it's not a sort of individual by individual measure basis. It is sort of all or nothing kind of situation. And then this one sort of is an update. This is board policy 3312 regarding contracts. So some of the substantive work that came out of these two bills that were passed, SB 1439 and SB 34, we actually updated them previously this year in board bylaw 9270 related to conflicts of interest. We also updated in this packet the 3312 to sort of align with that, but it's a good opportunity to remember what in particular SB 1439 said, which was that if you have a financial interest, and this is a quote, in a proceeding involving a license, permit, or other entitlement for use, which is which could be sort of a broad phrase that you have to be very wary and probably can't accept campaign contributions of 200 or more than 250. So how might this come up? I mean, we're not, you're not going to be a city council member who's looking at sort of, zoning permits and things like that, but perhaps if you have any charter schools and there's a Prop 39 lease coming forward, or any other leases, to any sort of private entities, that could potentially be triggered by this. So while the particular update is only 1312, it's a good opportunity to sort of remember and be aware of and to sort of track on these sorts of things. So the third one I'm going to talk about is actually a board bylaw, 9124, related to attorneys. We want to clarify in particular the distinction in this one between the district board bylaw and the county board of ed bylaw. For the district one, we adjusted the board bylaw to clarify that districts, although we're not required to use an RFP, that they can, if they want to use an RFP, when you go out to solicit proposals for legal services. Obviously, if you have in-house, that's potentially different, but most districts don't, and so most districts are going to go out. Again, not required, but sort of suggested. And there's been some situations in the news related to this that I believe motivated the sort of this piece of it. And then for county boards, so county boards are interesting because in most situations, the county superintendent does not report to the county board. So this particular bylaw talks about, when would a county board be able to appoint counsel independently of the county superintendent? Typically, they're going to be done together. It's a joint representation. But if there is a conflict of interest that necessitates that the county board retain separate counsel, then you may do so. So those are the two key pieces related to 9124. Okay, so I am the last policy that we're going to discuss, but I do have one more thing I want to mention. So in addition to today's amazing webinar, there is a webinar tomorrow that's at 2:30, and it is all about Assembly Bill 1078. So for those of you who are not familiar, it relates to the adoption or rejection of instructional materials and the use of instructional materials for school districts. It does allow certain complaints to be filed directly with the state superintendent for public instruction. It imposes the possibility of financial penalties, and those didn't exist before. It sort of alters, really impacts the UCP and Williams Act complaint processes. And because it's an urgency measure, it has gone into effect immediately. The governor signed it, I believe, yesterday, or I think yesterday, maybe Monday. But anyways, it's this week, and it's in effect as of now. So if you're interested in learning more, just go to csba.org/webinars, and it's tomorrow at 2:30. It's not explicitly about policies. It's more about what AB 1078 does. However, we are releasing a special policy update next month that is going to update quite a bit of policies that were impacted by AB 1078. You see some of those listed on this slide. So regardless of whether you attend the webinar tomorrow, please make sure to take a look at the policy updates, or look for that. They'll come out next month. And we hope that you find those helpful.
Thank you so much, Josh. Okay, before we get to our Q&As, here is the contact information for any questions or needs you or your district may have related to CSBA policy and or legal services. And now we will start with the Q&As. So I will get to the first question. The first question is there any current law that governs the use of AI in schools? I'll generally state no, but I think Dustin and perhaps Josh could add into this.
None specifically addressing the use of artificial intelligence. What we are doing through the task force and of reviewing our technology use policies is working to update those and ensure they're aligned with the practices. Hopefully there will be some emerging guidance from the state. I know they have some webinars they just announced this week that'll be attending to hear more guidance from them.
Great, thank you, Dustin. Okay, let's go to our next question, which is what is piggybacking? A general description is when you kind of add on to another contract, but I will let Maryela or Meghan take this one, as I know they were specific to the policy development and the legal analysis.
I can answer that. It's kind of what you would think based on the term. It allows school districts essentially to purchase certain type of property from a vendor. There's no need to competitively bid this contract. They can just sort of, and here's the term, piggyback on a contract that the vendor has with another public agency. So they don't have to go through the process. They can just sign on, in essence, to an existing contract, so long as the same terms are used in the new contract. So it has to be the same contract. You can't add new terms to it, but the advantage of it is that you don't have to go through competitive bidding. And again, that's for personal property. You cannot do that for real property.
Thank you.
And I'll just add, if I can, Barbara, just to add the philosophy behind it, may be helpful a little bit. So, if I'm a district and I want to buy a bunch of pencils and my neighboring district just bought a bunch of pencils, the state says, well, you don't need to go through the RFP process or the competitive bid process, all over again. Your neighbor just did it. So you can just basically take what they did and assume that you're getting the best price. But as Maryela mentioned, it has to be the exact same contract and there are some exceptions. So you should definitely want to make sure that your staff is consulting the proper attorneys to make sure that you have good direction on that.
Okay, thanks to you both. The next question, what are the benefits and drawbacks of using design build? Again, I'll start off. I believe the benefit was to create a cost savings for districts and rather than having to do two separate contracts, but I will let Meghan and Maryela kind of go further with this.
Meghan, did you want to answer this, or do you? I can go ahead and do that. I don't want to leave you out of the discussion.
You can
whatever is okay. So essentially, like Barbara mentioned, and as I mentioned before, usually what happens is that there are two components, right? There is the architect and then the contractor. With respect to design build, they are both combined into a single entity. You do save time and potentially money as well and continuity. You get that continuity from having both of those components, the architect and the contractor, within the same design build entity, and you kind of get all of that competitive bidding at the outset, as opposed to having to go through it, to go through two different contract processes, one after the other or in conjunction, but in any event, having to go through the contracting with multiple entities.
Thank you, Maryela. The next question, why is it just ARs that are updated for bids, contracts, and services? For a bunch of these, I believe we just have ARs because they're much more procedural than board action or board direction. And sometimes, just as a matter of our work, sometimes we'll find that there's just a very small or technical change that needs to be done in one document. It could be a board policy, it could be an AR, it could be an exhibit. And so we don't put that through a formal update process. I will let Meghan, though, please. She's the one who was the drafter of these policies for the September update. So Meghan, do you have anything more to add?
Sure. So I'll just add that, so for some of these, there is no board policy. We don't have one. It's just the AR. So for things like the design build contracts, there's no board policy. It's just an AR. And that's because, like Barbara said, it's pretty technical. And then for things like 3311 for bids, there is a board policy and there is an administrative regulation. And in some cases like that, we've determined that the updates were only really needed in either the board policy or the AR. So we may have made some small changes, which we call a technical revision to the board policy, and that would be released as a technical revision. There wasn't any material changes made to that board policy.
Okay, great. Thank you, Megan. Okay, next question. In light of Education Code 44042.5, do we need to proactively renegotiate our CBA, our collective bargaining agreement? Maryela, can you address this?
Okay. This is, of course, dealing with the wage overpayment that I discussed. If the CBA or MOU is in effect on July 31st of 2022, then it controls. If there is an expiration or renewal after that date, then you do need to take into account Education Code Section 44042 and abide by the requirements of that section. Again, that's only if after July 31st, and if the CBA or MOU has expired after that date or is renewed after that date.
Great, thank you so much. And you might be able to help with this next question too. And the vote to recoup overpayment, is that vote an open session or closed session?
That's a good question. I would like to get back to you on that. I'm not quite certain, and I don't want to provide the wrong information. I'm not sure if anybody else would be able to provide a response to that, but I'm happy if, Barbara, you could take the name of the person who inquired, and I can get back to them with a response.
That would be great. Maryela, thank you for your thoughtful answer. So our last question is on share tables. I didn't fully understand the share table idea. Does it apply to all food offered at schools? Does it mean we won't be able to throw food away? Megan, I know you're our in-house expert on this right now, so I thought maybe you'd want to take this one.
Sure, happy to answer that. So share tables are for food that's offered by the cafeteria, so school lunches, school breakfast, school snacks. And there are certain requirements in order to ensure that it's safe. So things like whole uncut fruit with the peel on. So if you're offering apples or oranges, the students can take that. They decide they don't want to eat it, they can take it back up to the share table, and another student can take it to eat later that day or at that meal. They can take it home. And then there are certain requirements for things like milk. It has to be stored at a certain temperature. And same with perishable foods. So I know there are some grants out there as well through the state, and there are grants for like mini fridges and things like that, or school districts, cafeterias can have ice bins where the students can place their milk, and so students can take those to have multiple servings during a meal service, or take it home with them. And then food that's not utilized by students from the share table can then be donated to a local food bank. I hope that answered that question.
Yes, thank you. Well, we are getting close to being out of time, and I believe that is the end of our questions. Let me just double check. It is. So I'd like to thank you all. Well, first, I'd like to thank our panelists for their presentations, not only in the presentations, but the work that went behind it. And I would like to thank all of you for attending the September Packet highlights of the quarterly sample policy update series. And just really hope you enjoyed it and found it informative and helpful, and hope you have a great rest of your day.